we had at the agenda following the Katarzyna Zombory speech, Ferenc, Santha, Magdalena Kowalewska, Michał, Peno, and me at the end. Professor Rixer will be dealing today with the presentation of data on administrative court proceedings in Hungary. So I suppose I can turn things over you, Professor, and welcoming our guests, because I see several guests to our seminar, which is very good. Maybe we could share discussion at the end. So the floor is yours.
Thank you very much, dear Barbara, dear colleagues. As I have mentioned it earlier, under the provisions of Act 1 of 2017 on the Code of Administrative Court Procedure, a brand new institution has been launched in Hungary. From 1st of January 2018, in administrative court proceedings, the judge may, with the agreement of the parties, impose a court mediation procedure in the cases in which the law does not preclude it. So, today I'm going to speak about some facts and data related to court mediation in administrative court proceedings in Hungary. My presentation tries to introduce three relevant aspects of court mediation in administrative court proceedings. First, the number of cases settled via mediation. Second, the general facts about the former trainings on mediation organized for judges. And thirdly, I will also try to build in the results of some interviews conducted by me with judges, with representatives of administrative authorities, and with other professionals involved in the organization and provision of trainings for judges. So, I have to begin with some data on court mediation and administrative court proceedings. But at this point, we face some hardships. We do have the numbers of those cases in which settlements approved by the courts were reached in administrative court proceedings, but those numbers are aggregated ones, acquired by combining data on settlements reached without mediators and data on those cases in which professional judges were involved as independent mediators. So, I submitted a data subject access request to the President of the National Office for the Judiciary, asking for data on numbers of settlements reached exclusively by court mediation in administrative court proceedings. I haven't received the answer yet, but I hope that it happens within a few weeks and I'll be able to insert those numbers in the final version of my essay. So, what was the aggregated number of the settlements in administrative court proceedings in the last 5 years? It was 6 in 2018, 20 in the next year, 24 in 2020, 20 in 2021, and 16 in the first half of the current year. So it was 16 this year. These numbers are not so high, but we have to take into account that they are slowly increasing and that the total number of administrative court cases declines since 2019 at the same time. So we can say that these are not bad results. Just to give a detailed picture, there are at about 40 judges and assistant judges in Hungary who are entitled and officially assigned for court mediation in administrative cases. My second topic for today is the form and content of training on court mediation within administrative court proceedings. We have to highlight that between 2018 and 2020, there was a training dedicated to the specific field, but there are no such programs within the last 2 years. There were no such programs within the last 2 years. The reasons behind that situation are quite interesting. On the one hand, the COVID pandemic can be mentioned, and the fact that for such a sensitive field as mediation, online forms of training are not really suitable. Even though the so-called Q-Space e-learning platform was opened for the judges here in Hungary, on the 13th of July, 2017, including an almost 2,000-page learning material. But from my perspective, not that first reason was the main one behind the lack of those trainings. Two theoretical approaches on the goal of the courts in general are really in competition with each other in Hungary. The first theoretical approach says that we should put the decision about their own lives within the hands of the parties, if it's possible. And such a perspective means that we should strengthen all the forms of ADR, of alternative dispute resolution. But another approach also exists parallelly here in Hungary, which says a judge is there on the pulpit to make judgments, and whatever happens, it must remain his or her main role there. And some judges think and allege that the second standpoint is the stronger one nowadays in Hungary. And this would be the reason behind the lack of the trainings. There is a specific institution, the Hungarian Academy of Justice, which operates as one of the departments of the National Office for the Judiciary, aimed to organize and provide trainings for judges and judicial staff. As we all know, the professional judicial activity can only be guaranteed by high-level trainings for judges, assistant judges, and judicial employees. The training of almost 11,000 employees working for the judiciary shall be performed partly centrally and partly on the level of regional courts and regional courts of appeal, with the central coordination of trainings by the Hungarian Academy of Justice. Almost all the trainings organized by the Hungarian Academy of Justice cope with the requirements of the provisions of the decree of the Minister of Justice and Law Enforcement on the mediation training and further training. Even though there are no specific trainings or court mediation recently, according to some inside information, kind of a further 2 days long training is planned to the next year, especially for appointed court mediators, providing some further methodological knowledge. Between 2018 and 2020, as I've already mentioned, there was a training for judges and assistant judges dedicated to the specific topic of court mediation. The training consisted of two parts, one theoretical and one practical. And the Academy had provided written materials also, especially a textbook on case law, to facilitate an understanding of the case law and also the specific requirements beyond the legal circumstances. Simulation exercises were also held, encouraging the judges to research precedents similar to the real ones. Simulations were fully interactive exercises that tested the capability of judges to respond to simulated situations, even in those situations where specific skills were needed. Practicing court mediators and other experienced judges were also involved, both in the theoretical and the practical part of that training. It was a huge success, according to the allegations of the participants, that the groups of maximum 15 were mixed ones, consisting both of judges and assistant judges. In some cases, well-known Hungarian actors were also invited to play the roles of the parties. My third point for today is the presentation of the results of those 10 interviews conducted by me with judges, with representatives of different administrative authorities, and with other professionals involved in the organization and provision of trainings for the judges. As you can remember, I had presented 6 questions of my planned survey questionnaire on the 5th of September. Among others, there were such questions as: what are the reasons for the use of court mediation by the parties within administrative court proceedings? why does the defendant, according to your experience, undertake the participation within that process? Or another question was, what are those case types within administrative court proceedings in which court mediation is most frequently used? Should we broaden that scope of case types? It has become obvious for me that such questions can be tackled only by having a research permission from the president of the National Office for the Judiciary, and it is not possible because of the serious time limits of this research. So I decided to make those interviews without those really deep and specific questions that refer to certain cases. And at the very end of this process, only two questions remained. The first one was that what should be the content of the materials of training courses dedicated to the court mediators? What are the skills that court mediators need to be successful? And my second question was, what are the main obstacles that block the growth of the numbers of settlements reached by court mediation within administrative court proceedings? The interviewees were 6 judges, 1 representative of an administrative authority, also regularly involved in such cases, 1 lawyer, 1 organizer of trainings for judges and assistant judges, and lastly, 1 former provider of such trainings who was not a jurist. So there were 10 interviewees at all. In answer to the second question, there were no surprises. Several answers refer to the mandatory or obligatory character of administrative law, and also to the fact that in most of the cases, not both the parties are interested in a settlement. Many answers pointed to the fact that administrative authorities had become interested in settlements only in those cases where the result served as a precedent for a huge number of similar forthcoming cases, and the authority was able to express its legal standpoint through its specific institution on time or even in advance. So the authority tries to preempt the huge number of further legal proceedings by such settlements. Answers given to the first question were very homogeneous. Empathy and initiative attitude are those features that are needed the most if someone serves the public as a court mediator. Some mentioned also that several judges make the mediation process formal because it is hard for them to leave behind those old habits. Thank you very much for your attention.
Thank you very much, Professor. So the results are, I suppose, interesting at some point. I have one question, but I will provide you during discussion. So just I must put it in my file. Okay, the second speaker for today, Dr. Zombory, Katarzyna Zombory, and her speech will be on the Polish legal framework for return cases and mediation under the 1819 Hague Convention. Please, the floor is yours.
Thank you, Professor, and dear colleagues, good afternoon. Thank you for the possibility to give my presentation today. My research during this project has been twofold. In the first part, as you may remember, I examined the international legal framework relating to the cross-border child abduction and mediation. But in the second part of my research, I have been examining the Polish regulations in the field of international child return cases under the international mechanisms of cooperation. During our last seminars, I presented the international context, And today I would like to focus on the Polish legal framework for return cases and for mediation in such cases. At the beginning, I would like to share with you some numbers and facts. The first fact is that binational marriages, so-called mixed marriages, are increasingly common for Poles, especially since Poland's accession to the European Union in 2004. It is estimated that currently almost 2 million Poles live abroad long-term, that is for more than 1 year, and most of them in Europe. Long-term stay abroad leads to establishing new interpersonal relations, either with other foreigners or with citizens of the host countries. It is very difficult to give precise data as to how many Polish citizens are married to foreigners, because many such relationships have been formed outside of Poland. However, in one of the articles that I read during my research, I came across the information that there are at least 1 million Polish binational marriages abroad. Whether it is true, I don't know, but the number is really big. And there is a very interesting fact about the binational marriages of Polish nationals. That is that most of such marriages are concluded by Polish women with men from other countries. On average, Polish women marry foreigners 3 times more often than Polish men marry foreign women. The truth is that my personal case only confirms this rule. Well, it may sound very funny or irrelevant, and we may, of course, wonder what the reasons for such a phenomenon are, but we need to be aware that it is not at all insignificant if we consider the demography of international child abduction. Nowadays, the typical case of international child abduction is that the mother abducts the child and takes the child to a foreign country, most commonly to her home country. So the judicial proceedings initiated upon a return application will often take place in the home country of the mother. So if we have many Polish women involved in binational relationships abroad, and we do have, there is a significant probability that in case of a child abduction, the return application will be heard by the Polish courts. Ever since Poland ratified the Hague Convention, and that was in 1992, the number of return applications submitted to the Polish authorities has constantly been growing. For example, in 2003, Poland received 18 return applications. In 2015, there were 93 applications, and in 2020, there were already 144 applications for the return of a child that were submitted to the Polish authorities. And here I am referring to the statistics to show you how relevant in the Polish context is the subject of cross-border child abduction. And it is very important to have a proper regulation for such cases, which can also accommodate specialized mediation. In my previous presentations, I already spoke about the advantages of mediation in cross-border family cases, so I will not repeat it today, but instead I will try to focus on the current Polish regulations. As I have mentioned before, Poland is a state party to the 1980 Hague Convention. In the intra-European Union cross-border child abduction, Poland applies the Brussels II terror regulation, which complements the Hague mechanism. In the period directly following the ratification of the Hague Convention, Poland did not have any special legal regime for the Hague return cases, because the general rules of the Polish Code of Civil Procedure applied. It changed in 2001 when a separate set of rules for the Hague proceedings was introduced into the Polish Code on Civil Procedure. However, it soon turned out that the regulation was not efficient. One of the main problems was the lack of specialization among family judges who are hearing the return applications. Over 300 courts were competent to examine Hague cases in first instance, and more than 40 courts had jurisdiction to examine the appeals. There was rather a low recurrence of the Hague cases, so the judges were not specialized in this type of family cases, and that also leads to the problem that the judicial proceedings in such cases were very, very long. In 2018, there was a major reform of the Polish regulations on the child return proceedings. One of the main challenges was the introduction of concentrated jurisdiction. Currently, only 11 regional courts are competent to examine return applications in first instance, and all the appeals are heard by only one court, the Court of Appeal in Warsaw. The Hague return proceedings in Poland are regulated in the Act of 26 January 2018 on the performance of certain activities of a central authority in family proceedings and in the relevant provisions of the Code of Civil Procedure. Such proceedings are carried out in a non-trial civil procedure, which consists of two stages. The first stage takes place in the court, and it is aimed at determining whether a return order shall be issued. During that stage, the social background of the child should be examined, but the court cannot take any decision on parental authority or custody rights. The second stage of the Hague proceedings in Poland is the enforcement of the return order. The court of first instance shall reach a decision within 6 weeks, and a similar deadline is provided for the Court of Appeal. The current Polish regulation contains no separate provisions on mediation in cross-border child abduction. The only exception is the Act on the Central Authority, which lays down the obligation of the Polish Central Authority, that is the Ministry of Justice, to notify the parents about the possibility of using amicable methods of dispute resolution. Apart from that, mediation in the Polish Hague proceedings is not specifically regulated. The general provisions of the Code of Civil Procedure on mediation apply. Based on that, we can say that mediation in cross-border return cases can take place before the commencement of the court proceedings on the basis of an agreement between the parties. When the case is already pending before the court, it is possible to conduct mediation both on the basis of an agreement and on the basis of a court order, which refers the parties, so the parents, to mediation. Regardless of the legal basis, mediation is a voluntary process, even in case of a court referral, because it always requires the consent of both parties. The Polish Code of Civil Procedure generally promotes the use of mediation by laying down in several provisions the obligation for the court to attempt to reach an amicable settlement and to encourage mediation. While trying to reach an amicable solution, the court might, for example, refer the parties to mediation at each stage of proceedings. The possibility of referral to mediation shall always be carefully considered and assessed by the court. The courts have discretionary power to decide whether mediation is appropriate in the particular case, that it will not delay the proceedings or otherwise be contrary to the best interest of the child. There is also another possibility to encourage mediation, which lies in the regulation, allowing the judge to summon the parties to participate in so-called information meeting on mediation. The court, which is referring parents to mediation, should appoint a mediator. While doing so, the court should first consider the list of permanent mediators, which is available in every regional court, and choose a mediator with appropriate knowledge and skills related to the conduct of mediation in cross-border family cases. Of course, parents may also choose the mediator themselves. The duration of mediation should be determined by the court. As a rule, in civil cases, mediation proceedings shall not exceed 3 months. On the other hand, we have the requirement of the expeditious proceedings and the 6-week time limit, which stems from the international documents. So the Polish court, seized with the return application, should set a much shorter time frame from mediation than the general 3-month deadline. If parents have reached an agreement before the mediator and assigned a memorandum of understanding, this memorandum of understanding needs to be validated by the court. The court refuses to validate an agreement reached before the mediator if it is contrary to the law or social norms, or intends to circumvent the law, or where it is incomprehensible or contains contradiction. Despite rather favorable legal environment for mediation in civil cases in Poland, the practice of mediation in cross-border child abduction cases so far has been very limited. For example, one of the Polish scholars dealing with this subject, Marcin Białecki, examined 30 return cases that were initiated in Polish courts shortly after the reform in 2018. And he found out that only in 3 of them mediation was used. The reasons why mediation is underused are probably multiple. And in the chapter, in the book, I tried to identify at least some of them. I would like to present them to you during our next seminar. And I will also speak about the possibilities to improve the use of mediation by giving some recommendations for the Polish legislator. Thank you very much.
Thank you very much, Katarzyna. As always, brilliant. And now we move to the next speaker for today, Professor Santha. I don't know whether you will be the presenter or Professor Jasko today.
Today I will the presenter, and Judith will help me to the PPT, but the presentation is our common work, of course.
Of course, as always. So please, I'm turning things over you, and you can start. So share your screen or.
Yes. I don't know, Judith, can you use the PPT, our PPT?
I see that Professor Jasko has some issues with connection right now.
Yeah, Judith, I will try it. Okay, so.
But if not, you can still send the presentation to our assistant for today, which is Agata Wrubel, and she will be eager to help you. Okay, but that's work. So the floor is yours.
Yeah, okay, thank you very much. Thank you, Professor. The possibility, I'm glad to be here again, and you can see the topic and the title of our presentation, namely the new opportunities and challenges of victim-offender mediation and reparation. This will be the first part of this topic, namely the mediation in juvenile delinquency cases. So we have a hypothesis again, so you can read our hypothesis concerning the victim-offender mediation in juvenile delinquency cases, that restorative approach is fully consistent with the principles of the so-called child-friendly justice. The conflict resolution methods used as part of diversion are of particular importance in juvenile criminal cases. Victim-offender mediation and other possible forms of restorative justice can be an effective tool for treating child and juvenile delinquency. And next topic, you can see the main questions, the subtopic of our presentation and the future article. The first question, what are the special provisions for juvenile offenders in the Hungarian Criminal Code, and what are the specific aims of criminal sanctions concerning juveniles in Hungary? The second, what are the reasons why mediation is ideal in juvenile criminal cases? The third, what are the characteristics of victim-offender mediation in cases of young offenders, and what are the practical experience, the numbers, and the fourth, what are the other forms of restorative justice for juveniles? So first of all, the special provisions for juvenile offenders in the Hungarian Criminal Code, and firstly, the definition. Who is the juvenile offender? Juvenile offender shall mean any person between the age of 12 and 18 years at the time of committing a criminal offense. This provision, correctly interpreted, means that the Hungarian Criminal Code determines the minimal age of responsibility in 14 years as a main rule. Any child under the age of 14 cannot be made responsible by criminal law. However, in case of, for example, homicide, battery causing life endangerment or death, robbery or plundering, if the child was over the age of 12 years at the time of the commission of the crime, and he or she has possessed the capacity to understand the nature and consequences of his acts, he or she can be held liable. He or she should be considered as a juvenile offender. And the regulations concerning juvenile offenders in Hungarian Criminal Code, there is no separate act concerning juvenile offenders, so the provisions of the Criminal Code shall apply to juveniles, with the exceptions set out in the Chapter 9, provisions relating to juvenile offenders. So no separate act, just a separate chapter in Hungarian Criminal Code concerning juveniles. Always important the aims, the purpose of the criminal sanctions. The general aim of criminal punishment in Hungary and Hungarian Criminal Code is the prevention, general and special prevention, and the defense of the society. But the situation is a little bit different concerning juvenile offenders, because according to the Hungarian Criminal Code, the primary aim of the criminal punishment or measure imposed on a juvenile is to enable them to develop in the right direction and become a useful member of society. In this respect, the choice of the measure or punishment should be made with a focus on the education and protection of the juvenile. I have to emphasize, the code emphasizes that the primary sanction is a measure, is the criminal measure. Criminal punishment should only be imposed on a juvenile when the use of a measure is inappropriate. And the third important statement by the code, that the custodial sentences, the prison sentences as ultima ratio, a measure or punishment involving the deprivation of liberty may only be imposed against the juvenile offender if the aim of the measure or penalty cannot otherwise be achieved. And we have to emphasize that restorative justice can be an alternative measure to prison as well. The next topic, the next question, is the reasons why mediation is ideal in juvenile criminal cases. The first reason arises from youth as a specific stage of life. In the case of youth, personality development is not yet complete, and the process of socialization is still ongoing. The possible negative experiences of a criminal proceedings and the solutions that are capable of achieving real remorse and understanding of the moral element of the offense also have a greater impact. The second is the time lapse. The time lapse that often occurs in traditional criminal proceedings reduces or eliminates the educational effect. The time lapse may be linked to the breakdown of the relationship between the offender and the victim. The victim becomes more and more an enemy or opponent for the accused, and the so-called victim denial may appear as a neutralization technique. In contrast, if within the framework of the mediation process, juveniles are forced to face the victim as a person and the damage and suffering they have caused, it is an experience they cannot turn off even with their neutralization techniques. The third reason that during mediation, the victim is transformed from an impersonal concept into a living person, a person with feelings and pain. A quick and direct reaction to the crime can increase the educational effect. The possibility of mediation allows the young person to gain the trust of the community and the victim himself. Young person is taken seriously and become an active participant in the process, a person who has the freedom to decide, but must bear the consequences of his or her decision. Young person is treated as an adult. He is given moral credibility, and his coming of age in this sense can reinforce the educational effect of the whole process. And the fourth reason, mediation can also be used to mobilize the microenvironment of the young person. It can also give family and community members the opportunity to express the negative effects of the offense and to find a solution. Mediation can therefore help the juveniles to regain the trust that they have lost in the society as a result of the offense. The third question, the third topic, is the characteristics of mediation in cases of young offenders. The legal background of mediation for juveniles is almost identical to the legislation for adult offenders, and maybe you remember that two types of mediation in Hungary: the traditional mediation, the process in order to apply the active repentance as a ground for exemption from criminal responsibility, and the scope of relevant crimes are limited, and there are differences between the provisions relating to adults and juveniles. The situation relating to adults, that the criminal offense is a misdemeanor or a felony punishable with a maximum imprisonment of 3 years. And in case of a successful mediation, the criminal procedure is to be terminated. But if the above-mentioned felony is punishable with maximum 5 years imprisonment, the successful mediation will not terminate the procedure, but the penalty may be mitigated by the court without limits. And juveniles, relating to juveniles, the offense, the relevant offense, is a misdemeanor or a felony punishable with a maximum imprisonment of 5 years. And as regards the legal consequences concerning juveniles, there is no distinction. For them, a successful mediation process always means that the case is closed. And the second form of mediation, the new form of mediation, maybe you remember that mediation process in order to make reparation for the consequences of the offense and to obtain a lighter sentence. The scope of relevant crimes is not limited. This type of mediation process applicable in principle to more serious criminal cases, and grounds for refusing mediation do not apply in this situation. And the legal consequences, the most important, that successful mediation is only a mitigating circumstance to be taken into account in court proceedings. So no difference between provisions concerning juveniles and adult perpetrator. And the second subtopic is the practical experience of mediation in cases of young offenders. You can see the the numbers, the statistical data, the number of mediation process concerning juvenile offenders. You can see that 2015 was the top year when the number of the mediation process was the highest in Hungary. And if you can see the number in 2021, we have to say that the numbers of the mediation process are constantly decreasing. We have to examine what are the reasons for this for this tendency, for this kind of negative tendency. I mention only two reasons. The first, which I mentioned concerning mediation process concerning adults, that the prosecutor has several other forms of diversion at his or her disposal. In this situation, in this occasion, I just mentioned the conditional prosecutorial suspension of the procedure. And the second reason, the general opinion, the general so-called attitude of the prosecution service on the mediation in juvenile cases. First of all, you can see the details of the conditional prosecutorial suspension of the procedure. In the framework of this legal institution, the prosecutor may suspend the investigation for a specified time period if law-abiding behavior can be reasonably expected from the juvenile, and the legal consequences, the termination of the case if it's successful. In case of juveniles, it can also be applied in more serious cases if the perpetrator committed a crime punishable by a maximum of 8 years imprisonment. And the point is, concerning our topic, that the prosecutor may prescribe rules of behavior for the suspect, among others, to compensate the victim for the damage or loss of property caused by the crime. This is the reparation element of this legal institution. And the second important element of suspension of the procedure is that the prosecutor may order the juvenile perpetrator to be placed under probation with supervision. This is a criminal measure in our criminal code for the duration of the conditional suspension. Within the framework of probation with supervision, the prosecutor may prescribe mandatory standards of behavior for the juvenile to follow, which the probation service is responsible for monitoring. So they, the prosecutor and the probation service, can keep their eye on the juvenile offender in the longer term. This form of diversion may seem more effective to the prosecutor, to the prosecution service, than mediation. If the mediation process is successful, no criminal penalties or measures can be applied against juvenile perpetrator. And the second reason of this tendency that I mentioned, that the general opinion, the general attitude of the prosecution service on the mediation in juvenile cases, based on a Hungarian scholar, Tünde Barabás, from 2014. According to the scholar, according to her, the majority of juveniles are not able to express regret for their offenses during the mediation process. This is the first. The second, mediation process rarely works from a preventive point of view. And the third, the juvenile is usually unable to pay reparation. It ultimately becomes the responsibility of the parents if they are able to do so. I have to say that this really problematic, because the real purpose, the real aim of mediation is less realized, as reparation is not done by the juvenile, but his parents. And finally, I just mentioned other legal institutions which contain a restorative element for juveniles. There are legal institutions at the disposal of the prosecutor, namely the suspension of the suspension of the procedure by the prosecutor, which I mentioned. The second is admonition, which is the mildest criminal measure, and the third is the agreement on the guilty plea and its consequences. And there are other legal institutions, criminal sanctions actually, at the disposal of the criminal court, namely probation. This is a criminal measure in our system. In case of juveniles, it can be applied to any crimes and can be combined with supervision by the probation service. The second is the restitutional work, which is criminal measure. And the third is the traditional community service order or community service work, which is a criminal punishment in our system. Thank you for your attention.
Thank you. Actually, I would like to deal today also with juvenile delinquency aspects, so maybe we could share something. And I'm writing down the question to you right now on the chat, so please look at it. So now is the time for the next speaker in the field of criminal law and criminal procedure, Professor Magdalena Kowalewska, and her speech is on mediation in Polish criminal proceedings, the lege ferenda, Postulates. Magdalena, please, you can start your speech.
Yes, thank you. Good afternoon. Just give me 5 seconds to find the presentation. Can you see the presentation now? Is it visible for you?
Yes.
Yes, it is.
It's okay, great. Okay. And the slide has changed. Okay, great. So at our last seminar in September, I tried to talk about what the victim can obtain from mediation on a victimological and psychological level. In this context, I have also tried to give some insight into the formula of so-called victim-sensitive mediation. Today, it is probably time to consider the possibility of putting the assumptions of this formula into practice. I mean the possibility of reflecting it in the provisions of Polish legal regulations concerning mediation in criminal proceedings. I mean the CCP and the regulation of the Minister of Justice. Certain legislative changes would perhaps contribute to a real strengthening the role of mediation in criminal proceedings, to more frequent use of this institution by the organs of proceedings, and above all, to greater interest in mediation among the victims. It can be repeated endlessly, and I think I repeated the 4th or the 5th time, that currently less than 1% of criminal cases in Poland are submitted to mediation. Coming to the point, the regulations on mediation in Polish criminal proceedings, I mean the stage de lege lata, was presented in my first paper at our July seminar. The provisions from the CCP on mediation, I mean Article 23A, are quite general and regulate rather neutral formal issues related to the mediation procedure. It seems that the appropriate place for a possible legislative reflection and changes on the victim-sensitive mediation formula would be the provisions of the regulation of the Minister of Justice from 2015. This regulation sets out in some detail the procedure for conducting mediation in criminal cases and the conditions to be met by the institutions and persons authorized to conduct mediation. Indeed, it seems that for the possibility of positive outcomes from victim-sensitive mediation, the crucial factors are the proper design of the mediation procedure and the provision of an appropriate level of mediation and, of course, appropriate level of mediators. On the conduct and organization of mediation proceedings, the mentioned regulation of the Minister of Justice says in general that once a case has been referred to mediation, the mediator shall immediately make contact with accused and the victim to set up a date and place to meet with each of them, then conducts individual or joint preliminary meeting with the accused and the victim at a time and place convenient for them. Finally, the mediator conducts a mediation meeting with the accused and the victim and a place and time convenient for the participants. And the mediator also helps to formulate a settlement agreement. Plus, as a general rule, mediation proceedings shall not be held on the premises occupied by the participants or occupied by their families. This outline of the mediation procedure from this regulation of Minister of Justice is rather enigmatic. Meanwhile, in the victim-sensitive mediation formula, the course of mediation and the importance of its individual elements are covered very precisely, are covered in detail. First of all, the guiding principle of victim-sensitive mediation is protecting the safety of the victim. It is even pointed out that the mediator must do everything that is possible to ensure that the victim will not be harmed. At every point of the mediation process, the mediator must ask himself, does this pose a threat to the safety and well-being of the victim? The safety of the victim can be ensured, for example, by an appropriate place for the mediation meetings. Furthermore, as I mentioned last month during our previous seminar, the victim may be accompanied by another person of his or her choice. And as I also mentioned at our last seminar, the attention is even paid to the arrangement of the room, the chairs in the room where the mediation takes place. It seems that these guidelines could be implemented in the regulation of the Minister of Justice on mediation in Poland by introducing provisions that allow for the participation in mediation proceedings a person chosen by a victim. Of course, this person would not have to be attorney formally appointed by the victim, but in principle, any person with legal capacity indicated by the victim and agreeing to do it. Additionally, consideration could be given to somehow liberalize the rule that mediation proceedings should in principle not take place on the premises occupied by the participants or their families. If the victim will feel more safe, more comfortable in his or her home, if this will increase his or her comfort and sense of security, then perhaps a legal guarantee of this possibility should be considered. Furthermore, the guidance on victim-sensitive mediation points out the relevance of the subsequent stages of mediation. For example, what I already mentioned a month ago at our last seminar, that the first meeting the mediator should have with the accused. If the offender is willing to participate in mediation, the victim can be contacted and a meeting can be arranged. It seems that such a systematization of mediation proceedings should result directly from the regulation of the Minister of Justice. Currently, it only indicates that the mediator should conduct meetings with the parties of the mediation, joint or individual, and then conduct the actual mediation meeting. So this is therefore an area for some changes, for sure. It also seems to me that an amendment of paragraph 15 of the regulation of the Minister of Justice allowing its wider application would be worth to consider. According to this paragraph 15, according to this provision, if it is not possible to have a direct mediation meeting between the accused and the victim, the mediator may conduct the mediation proceedings in direct manner, communicating to each of the parties the information, proposals, and position of the settlement agreement. Such indirect mediation does not seem to fit into the victim-sensitive mediation formula, in which the settlement is secondary to the mediation process itself and to being heard by the victim, and is probably not the most important thing at all. However, it should be agreed that in some cases, such indirect mediation may be an acceptable option. So it should probably also be allowed that such indirect mediation is also possible at the request of the victim. it is quite likely that the victim will be inclined towards mediation and the defendant as well, but the victim, for various reasons, will not be ready or will not be willing to meet with the offender in person. The possible changes I have mentioned, which could adapt the current form of the regulation of the Minister of Justice to the victim-sensitive mediation formula, are certainly not revolutionary and may even be perceived as certain nuances. They do, however, represent a certain shift of emphasis in the current mediation formula, which does not actually focus on the victim at all. Another area of legal regulation concerning mediation in Polish criminal proceedings, which in my opinion no longer requires a shift of emphasis, but rather revolutionary changes, is the issue of the requirements for mediators. Currently, in accordance with paragraph 4 of the regulation of the Minister of Justice, a mediator can be a person who is at least 26 years old, enjoys full public rights, and has full legal capacity, speaks and writes the Polish language, has not been validly convicted for a criminal offense, has skills and knowledge in conducting mediation proceedings, resolving conflicts, and establishing interpersonal contacts, and gives the guarantee of due performance of his or her duties. The penalty made of these conditions, I mean that the candidate for mediator has the skills and knowledge to conduct mediation proceedings, resolve conflicts, and establish interpersonal contacts, seems to be crucial. I think it's quite obvious. The prospective mediator's fulfillment of these conditions is unfortunately not properly verified under the current regulation, under the current legislation. Meanwhile, victim-sensitive mediation draws attention to the fact that the mediator's competence and role is crucial for the success of the entire mediation process, from the first initial meeting with the accused and the victim to the final version of the settlement agreement. Namely, it is pointed out that at the first meeting, a critical task for the mediator is to attend the victim, listening carefully, patiently, and sympathetically out of a genuine desire to hear about the victim's experience. Effective listening by the mediator gives the victim a chance to vent and validate his or her feelings. The mediator's attentive listening encourages the victim's trust and lets the victim know that he or she is a priority. Furthermore, the mediator needs to assist the victim in considering the risks and benefits of mediation in his or her particular situation and ensure that victims' expectations are not only connected with settlement and are realistic. The task of the mediator is, of course, also to guide the first meeting with the offender, appropriately prepare him for the meeting with the victim, and ensure that offenders' expectations are realistic. In doing so, it is pointed out, perhaps somewhat wishfully, that through a non-judgmental attitude and a positive, hopeful demeanor, the mediator conveys his or her trustworthiness and sensitivity to the needs of both parties, the victim and the accused. If such objectives and the role attributed to the mediator are to be achievable at all, even wishfully, persons acting as mediators should be adequately prepared for it. It must therefore be concluded that it is crucial that the mediator has an adequate level of experience and knowledge in the fields of victimology, psychology, and of course law, to be able to carry out the mediation procedure and guide the participants through this procedure. This experience and knowledge should be verified before a person is added to a list of mediators. The most sensible form of this verification seems to be an exam, a requirement for mediators to upgrade their qualifications, for example, by attending training courses in order to keep their knowledge up to date and improve their competences, also seems quite obvious. In short, if mediation in Polish criminal proceedings is to be a useful tool of restorative justice, bringing real benefits for the victims, not only economic ones, then it must be conducted by persons adequately prepared and trained for it. Currently, under the current regulation of the Minister of Justice, this preparation remains only a postulate and it's not verified. Therefore, it can hardly be seen as a condition for inclusion in the list of mediators. Increasing the requirements for future mediators would obviously entail further legislative changes. Indeed, the examination procedure, the examining body, etc., would have to be defined in detail. It is also clear that increasing the requirements for mediators would also have to entail a different way of paying them. However, these issues, I think, are secondary to the need to reformulate the current form of mediation towards a victim-sensitive mediation formula, and this undoubtedly requires a slightly different role and competences of the mediator. A different role, I mean, one that is more oriented towards the process taking place in the attitude or mentality of each of the parties of mediation, and not only towards signing a settlement agreement. The reality of mediation in Poland today is that a very large number of mediators are simply lawyers. Without prejudice to lawyers' knowledge, I am a lawyer as well, to lawyers' experience or even sensitivity and social competences in general, this is probably, in my opinion, not the most predisposed group of professionals to be mediators. The second area of legislative change in the current regulation of mediation may be related to making it more attractive from the perspective of the accused. I have already pointed out in one of my previous papers the need to consider a stronger link between mediation and the other consensual modes, sentencing without trial and voluntary submission to punishment. A possible tool could be also the consensual discontinuance already functioning in Polish criminal law a few years ago, although for a short time. It seems to me, however, that these changes would require a deeper reflection in general on how we want to develop consensualism in Polish criminal proceedings, in particular from the perspective of the accused precisely. On the other hand, the lege ferenda postulates that I have outlined today, connected with the victim-sensitive mediation formula, seems to be possible in a relatively short period of time and worth considering, which does not mean, of course, that they do not perhaps require further research or further reformulation. Thank you very much for your attention. That's all from me for today.
Thank you very much, Magdalena. And almost the end, but not. We have also two speakers before us. Professor Peno will continue with his previous thought, and with this correspondence, a few remarks on the theory of legislation, constitutional rules of the legal system, and institution of restorative justice. The floor is yours. And if I may say, I'm putting the question on the chat, and we can use them during mediations. If you would be so kind and please don't write your comment on or answers on the chat, and we can discuss this later during discussion.
Yes, thank you. I will show you my presentation, which is here. Yeah, traditionally I will begin by explaining my understanding of the restorative justice. Restorative justice is considered as more than mediation, simply put as working mediation based on a specific system of values and social change. In today's presentation, I would like to focus on the last element of the normative definition of restorative justice, that is a community. This is, of course, only an example and a point of reference, because as you probably know, the legislative directives are general, and of course we can use these directives, these rules about how to create and establish good and working law. We can use to or apply to every aspect of this conception. So of course restorative justice may be understood in several ways. But each concept of restorative justice treats crime as an act resulting in evil towards a specific person, a violation of interpersonal relationships and social bonds, assumes that a crime forms a specific obligation, and the main duty is to restore the damage, restore the evil. It is assumed that meeting this obligation, the ultimate objective of which is to restore the status from before the crime, restoring the results of evil and especially broken relationships. And that requires the involvement of the victim, who should be open to restorative process, the perpetrator, who should be open, of course, not only to the restoration process, but should also be ready to accept responsibility and repair the evil done, and of course the community. And I will try to focus on community, especially on the community today. So here we have three elements. To my mind, these three elements are important to legislator who wants to prepare a good restorative justice law or mediation law in this very broad sense. And we need both a proposal for the shaping of legal institutions and the ideas we want to implement, as well as the, I would say, content of specific provisions. And frankly speaking, the content of each specific legal act provision is the least important. I will focus today on directives of legal policy as social engineering directives, therefore relating to the effectiveness of the law. But of course, one can characterize the rules or these legal policy directives as patterns or guidelines, which are a kind of rules constructing the system of, for example, criminal law. So we know that we have to, if we want to introduce restorative justice institutions, we have to change something in the conception of criminal responsibility. We have to change something in principles of criminal process. Of course, it is also an important part of our work if you want to prepare this kind of legal solutions. But of course, what is extremely important is to work out directives, how to effectively implement this kind of norms. And here we have. This is, I would say,
I'm so sorry, Professor Peno, because we see still the first slide. I don't know.
It's. I'm really sorry. I don't know why. Okay, I'm really sorry.
Please try.
It works from my side. Everything worked perfectly fine, but of course, probably the old method would be the best method. So I will show you my presentation without this mode of presentation. So I now probably you can see this.
Now I cannot see your presentation at all.
Okay, sorry. I'm really sorry. It's a technical problem. I hope I managed to solve this problem.
Now it works.
Okay, of course it's not so good from an aesthetic point of view, but it works. So this is the second slide. I guess that I can go to the another one. This is a field of my today's consideration. And here we have, I would say, semiotical status of these directives that I addressed to the legislator. I would say, of course, we can discuss the problem, why these directives are obliged for legislator. I would say that this is a matter of a simple fact that legislator wants to create good and working and effective law. This is why we need this kind of directives. Of course, legal norms here are treated as an instrument of rational social engineering, as a determinant of the legal policy, and the objectives of legal policies are, of course, determined by the ideal of social life selected, chosen by the legislator, which should be implemented by the law. And of course, there is a question which values, objectives could be dictated by such an ideal, chosen ideal. So here is the main question. So what should be taken into account when selecting measure for the intended purpose? A very important thing, the basis for the formulation of such directives, legislation directives, must be our knowledge. In this case, knowledge about society, about values, about the existing mediation practice, about social expectations. So the first step is to prepare a, I think, quite broad project about mediation now in Poland, about social expectations, about values that are linked with mediation. And here we have a kind of hypothesis that each and every society must work out its own approach to conflict solution, including conflicts within legal relationships, including, of course, restorative justice, which is also a kind of method of managing conflicts in a society. So what kind? Here we have. I'm not going to read it. So I just highlight what is the most important from my point of view. We have to take into account moral aspects of society, cultural, legal aspects of society. So this is really huge diagnosis which have to be prepared, which has to be prepared before we start to start projecting legal acts. First and foremost, from the point of view of a community, we need to create a kind of collectivist or support a kind of collectivist culture in our society. This is a matter of culture and social order. Restorative justice, I just wanted to say that restorative justice is a good institution under collectivist culture conditions, not under individualist, plain liberal culture. Collectivist culture is, of course, it's a sociological idea, but it is also important from the point of view of theory of legislation, from the philosophy of law, and so on and so on. So collectivist societies, collectivist cultures place the collective good above the individual one. However, of course, this is not the exclusive characteristic feature. We need to support a kind of axiology preferring common good, altruism, shared responsibility before the utility of individual freedom or our individual expectation. our individual expectation. There is no point there is no point in assuming that we need mediation or quasi-mediation, restorative circles, and so on in, for example, family cases. If, for example, the duration of the marital relationship and the family is not a value, and it is not worth repairing difficult relationships. There is no point in taking about mediation in criminal matters if we just want to take revenge on criminals. If you want to achieve a social ideal in which dialogue, the offers of the other person, kindness, or mutual kindness, interpersonal relations count, then we should take certain actions. And of course, there is a question: what kind of actions? Okay, so it is important, I think, that court and adjudicative process means conflict. Mediation and restorative justice, kind understanding, forgiveness, personal values. We need to take into account these values if we want to, if we really think, if we do think that we need mediation, if we do think that we need restorative practices in our society. Okay, so here I have prepared social technical directives. Here are examples. I think that these examples are very general. I have specific directives in the article which I prepared about this problem. I think that this is quite good, quite important thing, that the principles of good restorative practices are value-led and informed by research evidence. We need that. We really need these two elements. So the first, what is the most important is the fact that the community is value and should be promoted. This is I would say an aspect of the organization. Involvement in the life of the community and solving its problems. It is also a very important aspect. I would say membership aspect of the process of introduction of restorative justice and mediation solution. So what kind of activities should be prepared by the state, by the legislator? In the field of education, of course, it is very important, I would say, starting point. We need public space for mediation. This is the second element. We should resign from utilitarian and instrumental reasons, which is very important for me, and I think that we should find other axiological background for that, not utilitarian, not instrumental. Mediation and restorative justice, it is not an institution which aims to I don't know, to limit cost of court proceedings, for example. Of course, building a collectivist culture of peace based on a set of values, traditions, and lifestyles favoring such ideas. And what is, I think, very important from the institutional point of view, it is not shown in this slide, but I think that we need an institution or body responsible for coordinating mediation and restorative justice, a kind of advisory evaluation, as well as research and training institution. And maybe we need also a kind of specific mediation law or restorative justice law as a individual specific legal act. So thank you very much for your time. Thank you.
Thank you very much, Professor Peno. So as you see, there are my questions, but please don't hesitate to start discussion, but maybe by inserting the new questions that we could use during discussion. And last but not least, my speech. So my topic for today is about the conception of conventional acts. I hope that you maybe have heard about the conception, but of course, as a basis to understand better mediation, mostly victim offender mediation in criminal cases. Before I start, I must say that I was rather skeptical when I decided to use a conception of a conventional act. So skeptical toward my like splendid achievement by application of this conception when it comes to mediation. I will tell you in an instance why, but I'm really impressed because actually there is a very important point, and when we try to apply the conception of conventional acts, it could be very practical, but mostly one area of practical assessments. So I know that our meetings are recorded as the previous one also, but I would like to return to my assumption, which I presented last time. So my assumption, I would say even acknowledgement to the groups of theories, which I'm trying to apply to better understand mediation and maybe to develop mediation as legal institution. So just to remind you, I divided those theory into three groups. The first I denominate as a core theory, and it was a conflict resolution theory. I decided that this one, it is the best theory to shape mediation as a legal institution, but mostly when it comes to the purposes of mediation. So when you want to answer the question how we could make mediation more effective, we must discover the purposes, maybe not one only, but purposes of mediation and the purposes of criminal procedure as a whole, and then combined those purposes all together. And then I decided to select the second group, which I denominated as the conception theory of optimization. And the third group, which I called a normative theory, normative legitimization theory. The last group I will discuss during the last seminar. So probably we must set this, but it will be at the beginning of December because the conference is in November, so we can manage with the last seminar term. So when it comes to the second group, so optimization theory, last time we discussed and I tried to show you the benefits from the communicative act theory by Jürgen Habermas, and there were some assumptions important to victim offender mediation, and one of the core issue was connected with the moment of entering into mediation procedure by offender. So the level of his honesty at the entrance and the legal requirements. So we established that from the legal point of view, it is enough to admit a commitment of crime by defendant, But when it comes to the communicative act approach, it should be something more. So offender, defendant should show the remorse, and maybe should be very honest at the beginning to create this this whole condition of good discourse. And today, this second conception which I'm going to deal, so the conventional act, it's also based on the same assumption in general, that we can see the mediation procedure through the act of communication, but from different point of view. So maybe I will try to describe you in short this conception of conventional act, but the version which I'm going to use, it is a version elaborated not only as a conception of conventional acts, but enriched by the Polish scholar from Szczecin University, which was connected also with Michael Peno, Professor Czapita. So the conception of conventional acts, it's a very renowned conception, I must say, based on the Austin theory of performative acts. And this conception is the core of conception has been established by Searle, and the author distinguished the rules, namely constitutive rules. And it is similar, like we can describe the rules of game. So the legal system is artificial and there are the rules. So to know that one action is a part of the legal system, we must know the rule. And the rules, all rules in general, and the rule of validity, it is a constitutive rule. It means that when you are at the point of infringe the rule of the constitutive rule, the rule of conventionalization, it could be say also, you are at the point of validity. Of course, lawyers think about all those rules only when they have doubt about, they don't think about each action, legal action, whether it is constitutive rule for this action or not, but they think about those rules when they have doubt about the validity, and mostly about the effectiveness of legal action. So it is connected with whole theory of the effectiveness of legal action in many sense, I would say, not only with validity, but also with effectiveness. So the theory based on constitutive rules, it means that there is a group of rules, the core rule, and we can attach those rules with the competence. And the sanction for infringement of those rules is a sanction of validity. A part of those rules, it is also other rules. For the procedure, it is, I would say, the most important part of rules. And those rules are known as rules of formalization. It means that there are many formal rules in procedure which are not constitutive rules, but they are important for effectiveness of legal actions and their presence as the sequence during the criminal, for example, criminal, but not only criminal procedure. So I know that this is quite abstract, but of course those rules are very important for criminal procedure, because we are always wondering, mostly when it comes to the action connected with evidentiary proceedings, whether this is an action which provides us an effect, evidence in criminal procedure, or when it comes to the judgment, we think, or whether this judgment is in some way could be in some way undermined. So in other words, whether the judgment is defected, and maybe it could be a basis for appellate procedure or other procedure of special remedy. But when it comes to mediation, we know that mediation procedure is not a part of criminal procedure itself, but is connected with procedure. Obviously, we can treat mediation procedure as a special legal procedure. But we know also that sometimes it's not connected with criminal law, but for example, with private areas of law, that it could be also a private mediation. Even private mediation must be enriched by special set of rules. Of course, it is extremely flexible procedure, private mediation, but even private mediation has a special set of rules. Maybe there are very flexible rules as well, but we can describe even when it comes to private mediation, a special set of rules, like the rules connected with the mediator, who must be someone objective. But right now, I don't want to speak about this private mediation, but mediation, connected victim-offender mediations on the special procedure, which is legal procedure. It is first. It is not a criminal procedure sensu stricto, but it is procedure which is a sequence of formalized and conventional legal actions. And in connection with the speech of Magdalena, we can say that obviously we need to have a very flexible level of mediation. So it means that mediation shouldn't be formalized at the very high level. But at the same time, we must be sure that mediation must be formalized at the point to be a procedure covered by certain set of guarantees. On the one hand, it must be flexible, but on the other hand, it must be sure when it comes to the position of the disputant and the position of mediator. So my first assumption when it comes to the conventional acts theory is that mediation must be formalized at some point. So it must be flexible, but at the same time, it must be formalized. It must be formalized when it comes to the starting of procedure and the end, obviously, but it is more complicated, and I will try to describe how we could use the constitutive rules theory in very productive way. But also when it comes to the position of mediator, the requirements toward mediator, the step of procedure connected with the appointment of mediator, selection of the persons for mediators, and so on. So even pre-selection of the core procedure conditions. But what was for me, I wouldn't say brilliant because it was my research, but what was for me very important from this constitutive rule conception when applying, it was that we have two formulas of mediation. As you remember, settlement-driven mediation and non-settlement-driven mediation. And in settlement-driven mediation, the result of mediation is settlement. And to the settlement, we must apply the provision of, when it comes to the enforcement procedure and so, we must apply the civil law, not criminal law anymore, not criminal procedure. And this is a point, because as I said at the beginning, constitutive rules are the rules connected with the sanction of nullity. And my research indicates that I think that we can use the notion and whole procedure of defectiveness toward the settlement in mediation, which are described in civil code And there are very important regulations connected with the expression of will. What is important? For example, we have the error, the legal error. We have the procedure how to declare nullity of the statement produced under pressure, under certain influence. So I think that first of all, to be not like that abstract, I can provide you one of those regulations. For example, Article 82 of the code of the Civil Code of the Polish Civil Code 1964. So expression of will shall be invalid if it was made by a person who, for whatever reason, was in a state of excluding conscious or free decision making and expressing her intent, his or her will. It shall in particular concern a mental illness, but not only, a mental retardation or other, even temporary or other mental disorder, but not only. So it is both the condition which apply to victims and offender when it comes to the settlement. There are also other defectiveness of the statement of will, which are described in civil law. And I think that all of them could be applied to the settlement concluded in mediation procedure. And what is more, it has impact on whole mediation procedure in criminal cases. Because I think that when there are those defectiveness which we could discuss in respect to settlement in VOM, we can also say that this measure, this feature, could help us to upgrade the same aspect we discussed previously when it comes to the motives and attitude of offender, mostly during victim offender mediation, because it is also this feature which is important because when it comes to the error or some pressure on a person when it comes to the settlement, it must be connected with a very high standard of accuracy and also the axiological attitude from the offender when it comes to this aspect means settlement between victim and offender. So to be concrete, I must say that the theory constitutive rules, which maybe was not that clear because I tried to describe you in very broad from the very broad perspective, could be very applicable and could have a high level of practice implication when it comes to the settlement concluded during mediation procedure. Of course, my inquiries were about the Polish system, but I'm almost sure that the same perspective could be taken to the other and could be taken as a basis for the analysis of other systems. So I think that it is quite a general approach. But I'm waiting for your questions, and I hope that I could describe my perspective in the detailed manner. So this is all from my part today. And if you could start discussion, it would be wonderful because we have a festival day. I don't know how it works in Hungary, but in Poland, those days are very, very special to us. We have this custom visiting graveyards of our families. So it starts today and is until 2 follows days. So it's a very festival time to share with whole families. So please don't hesitate to ask the question, that maybe we can start by responding my questions, if you don't mind. Maybe Adam, as you was the first.
Yes. Thank you very much, Barbara. Your question was that what are the fragile points of the court mediation in administrative cases? Or in other words, why is it harder to reach settlements in administrative cases? First, I have to say that the problems are substantial ones, not procedural ones. What does it mean? The first and main difference between the civil and administrative law is that the content of administrative law is more mandatory or more obligatory type, and the content of any settlement is strongly determined by the extent of the legal discretion provided by the law to the given administrative authority. It means that the scope of legal discretion is more narrow in administrative law as in civil law. The other thing is that the win-win philosophy of mutual benefits, the satisfaction of mutual interests within criminal and civil law cases can be justified also in Hungary, but in administrative court cases, it is not so easy to prove that, because why should the representative of a given administrative authority accept any changes within the decision in question? And if there are no legal obligations to do so, and there are some questions, and I have mentioned some possible answers, but for example, that settlements can be reached alongside the cooperation developing on a mid-term or long-term basis between the given administrative organs and certain clients, with benefits to both sides, if this cooperation is a longer one, or there are several cases and in which the one side is the same administrative authority, but none of these reasons are so obvious as in criminal or civil law cases. So this would be my answer.
Yeah, thank you for your insightful approach. And I don't know who would like to be answered next. Maybe Michał, because I see that you are smiling.
Yes, thank you very much for this. Yeah, it is. I would say that the first thing is that values are the side of the coin. Axiology is the first, but the knowledge is the second aspect. So I would say that we have to approach values scientifically, sociologically, but I don't know how to define Christian values, perhaps not as a moral doctrine of this or that church, but in the sense of the universality of, say, the 10 commandments. Yes, certainly restorative justice presupposes consent to a certain common system of values. In this sense, Christian ethics, the 10 commandments can be a good point of reference. The special role of mercy and forgiveness is a good axiological background. I'm not saying that we need ethical objectivity, that we have to believe in objective hierarchy of values, but something like that, similar, would be quite useful, I would say, if we have this kind of axiological core in our society or community. Of course, it makes this legislation task easier. Quite simple. If we are to talk about something and give it legal significance, we must recognize the subject of this meeting, conversation, and think as important. If all that matters is my freedom and that I should do what I like as far I not hurt another, then there is nothing to talk about, to mediate, to restore. We just need to deter or take revenge, that's all. But the matter of the other person does not interest me at all. Same with family and marriage. It must be something more than contract. We need a value as a background. If we agree for that, for the values, there is a sense to introduce mediation and restorative justice in a given community. So yes, I believe that, of course, Christian values can be treated as a core if in a given community we have this existing core of values, of course. So we need to prepare the legislative process from this, I would say, axiological but also empirical point of view. So yeah, I truly believe that that restorative justice is rooted in an idea of and the idea of shalom, of forgiveness, or evangelical, I would say, Christian values. Yeah.
Okay,
of course.
so because my question was based at the preamble of the new law of the responsibility of juveniles, which is expressly stated in the preamble that the whole system based on Christian values. And like this approach is a little bit controversial, not only because of those values, but also about other aspects of preamble. But let's try to check this and discuss later, maybe during our workshop, how we could describe the Christianian system of values and which point we are authorized we legislator is authorized to insert this expressly to the preamble of law. Okay, so if I may ask, maybe Katarzyna, could you maybe first provide us your comment on the seminar, and then maybe try to answer the question, which I
smiled when I read your question. It's a good question. However, I do not have statistics which refer to the nationality of the father. However, I have found in the meantime some statistics from the Polish Ministry of Justice as to the number of, not only about the number of return applications that were submitted to Poland, but also detailing the countries and the number of return applications from several countries. And I can share you, for example, the statistics from the year 2016. And in 2016, there were 105 return applications sent to Poland. And the vast majority of them, 43, were sent from the Great Britain. And then 11 from Germany, 6 from the Netherlands, and 7 from the Netherlands, and 6 from Ireland. It does not tell us what was the nationality of the applicant, but it still somehow is in accordance or in line with general information that we have, that the largest number of Polish communities abroad live in Germany, Netherlands, UK, and Ireland, and it is clearly reflected in these statistics, in the number of return applications. I hope you are satisfied with my answer.
My question was like I try to find this the point where you can develop maybe this part of your research. So maybe you could include this in your research by maybe dealing with this, because it was you who told us that the requests are from the families constructed with the Polish mothers. So my link was maybe it would be a good part of research to determine cultural context in this, and maybe it would provide us information about the obstacle of the procedure when it is created, when it has some links with the social, cultural, and national aspect. So this was the question to maybe make you think about this, not to get the answer.
Thank you very much. Thank you for your suggestion. Maybe it will be a part of my article, which will be a little bit more focused on the child and the position of the child during mediation.
Okay, but have you any comment on the seminar for today?
Not especially. I'm enjoying it very much as always, and yes, that's true. Also in Hungary, it is a period to be with the family and to think about the family, about the relatives. And I can tell you from the Polish perspective here in Hungary that it's very similar to how we celebrate it in Poland.
Okay, but it's a very actually particular, I would say, custom, and not very widespread around the world. So it's very this part of region, I must say, this attachment to the members of family who passed, and so I think that we must celebrate this time. But in short, we must put forward our discussion. And maybe now, I don't know, Ferenc, would you like to answer?
Dear Barbara, thank you first of all your comment and the question as well. Your comment was that the position of the victim in juvenile delinquency could be one of the features that increases the interest in mediation. I agree with this opinion, of course, and I can add to this that the attitude of the victim is the key factor of the success of the mediation process, especially in juvenile cases. And your question was that what is your opinion? Could you describe the position of victims in juvenile cases in Hungary? I have to tell you that the situation of the victim is not unique, is not special in the juvenile criminal cases or in juvenile criminal mediation. No special rules, for example, in the criminal procedure code, but I can mention two negative characteristics from the practice. This is not my practice because I'm a traditional defense lawyer, so I don't participate in mediation process. This is the experience of one of my colleagues that some of the victims assume in criminal mediation cases in juveniles that the juvenile cannot provide financial reparation and therefore do not agree to the mediation. This is the one. And the other is that mediators often cannot handle the activity or the activism of the juvenile's legal representative, who is usually one of the parents. Of course, the parent often behaves as a defense lawyer in the mediation process, and on the other hand, I can mention one positive characteristic that some of the victims believe that successful mediation has a significant educational effect for the perpetrator, the juvenile perpetrator.
Thank you very much. If you would be interested, I can say that in Poland, this issue of juvenile delinquency is more complex, and we have also the special law for juvenile delinquent in respect to punishable act. And in the act I mentioned, there is a special actually the special features, in my opinion, which provoke the victim to enter into mediation procedure. And one of those features is that the victim is not a party to the procedure. So the mediation is the unique way to enter into some existent, in legal sense, existent position. And the second, I think, is that in the procedure under the act, I think it's a special procedure for juvenile delinquents. It is that the victims are granted by a support of parents when it comes to compensation. So there's a special provision which could impose the obligation on parents or guardians of not young but delinquent offender. So it is, I think that in Polish criminal law, it is very important feature which increases the number of mediation. This area.
Thank you. Okay, thank you very much. Your comment, it's very interesting. Thank you.
Okay, thank you. And now maybe Magdalena, it is you, your time.
Yes, thank you very much, and thank you for your question. Trying to answer it, I think it is worth noting that a case is referred to mediation, I mean in Polish criminal procedure, by order, I mean postanowienie, order, yeah, order of a court or the public prosecutor. The parties of the mediation procedure also received a note informing them about the objectives and principles of the mediation procedure. So the initiation, the beginning of the mediation proceedings is very formal. And I think like with any formalism coming from the court or from the public prosecutor, to standard people, this formalism can frighten the parties of mediation. So I think that it would be worth considering some amendments in this area. Obviously, let's leave the referral to mediation by a court order or prosecutor order. However, in addition to this, the parties could get more available, easier information than a standard instruction about the nature of mediation procedure. Later, already during the mediation proceedings, I think that there is no reasons why contact between the mediator and between the parties of the procedure should be as informal as possible. Yeah, without any formal letters, any formal notes. It's just up to the parties and to mediator.
And it was what I thought. So but by this beginning, but also whole communication, because there is a strong discussion. I don't think in Poland, but when it comes to other types of victim offender mediation, how it must be, how the parties must be provided with subpoenas, how they must be informed step by step about the mediation. There exists a solution, as far as I'm aware, that it is a special first meeting to organize whole procedure, and the first meeting is with the participation of the parties, and then they have some impact of creating the procedure. I don't think rules of procedure of mediation, but how mediation, they are in some way creators of procedure. So maybe you can think about it in your research.
I will try to dig a little bit deeper in this point and overthink about it.
this meeting, this first meeting, could be an analogon of what we have in criminal procedure, which is the first meeting before session under Article 349. So, but in very, 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 very informal way when it comes to mediation, but like organizational meeting without any discussion on the content. But of course you can think. I would like to ask you if someone would like to share with us the last comment, or because I would like to prize whole speakers, whole performers. The research are very insightful. Yes, Adam, please.
Thank you very much. Just a short question to Michał. Thank you very much for your presentation, and you gave us several questions. For example, what should be the purpose of any legislation? What should be taken into account when selecting measures for intended goals of legislation? And you referred to aspects such moral, cultural, legal, and economic aspects within your answer. But by some simplification, I have to say that the best justification of any legislation is survival of the governing party. And on the other hand, that the new legal institution looks nice in the public media. So if the legislator gives that question to himself, then the main questions are that how does this new legislation influence the results of the forthcoming elections, or how does it look like in the public media? I mean, this new legal institution, always these are the main aspects, and because of that I suggest to implement the fifth and the sixth element to this list, the politics and the media, because these are, I think, as important as your other aspects, and these are independent aspects. These are beyond the elements you mentioned on your list. Thank you.
Thank you very much. Of course, the law is a result of political decision or a set of political decisions, and of course, the restorative justice as I would say a direction of legal policy and social policy also is quite risky. I would say that for example, from the point of view of a public opinion, the restorative justice can be considered as alternative for punishment, and at something what is totally opposite to functionally opposite to punishment. So yes, of course. So as something injustice. So I can see your point, but from the point of view of I would say for the point of view of a theory of rational legislation, I would say that if from the point of view of a rational legislator, the restorative justice reflects chosen ideal of social life, the legislator should do everything what is necessary to introduce this kind of legal solution. So there are two autonomous spheres or aspects, I would say. The first one is a political aspect, and the second one is an aspect of rational legal policy. And I believe that we can try combine these two elements, for example, in applying conscious and rational educational policy, for example, to prepare a society to this kind of solutions. So this is one thing which can be proposed or suggest also to prepare society to this kind of changes. But of course it is not an easy task to prepare society to this kind of solution. I truly believe that it strongly depends on society, on tradition of this society, on customs, and so on and so on. I think that in Poland it is quite possible to introduce at least partly this kind of solution, and it wouldn't be politically risky for ruling party.
Okay, we can decide that this was the answer, Professor Rixer. Yes.
Thank you very much.
Yes, thank you. Yeah, it is.
Because we can continue, obviously, with this topic, which is very flexible.
Broad topic, yeah.
Yes, everything we are discussing, I would say that everyone is trying to give a touch, mostly when it comes to the conclusion of research, because it is not that difficult to deal with the assumption, with some legal framework. But when we would like to achieve the conclusion, we should also select something to say, because the time is very strict, because it's at the maximum 20 minutes. So you cannot discuss that far as we wish. So I don't know whether someone would like to give us the last comment. I don't see any hand, which is right. I don't see any more, even you did. So please pass her the best regards, Ferenc, from today. And we will see you soon, 21st, 22nd November, during our conference. I just would like to know whether whole team is aiming to come. Ferenc? Will you be present?
Now I don't. I'm not sure to be present personally in this conference, but my question is that will be possible to join to the conference by an online form?
I suppose that it is planned as a hybrid form. So you mustn't come, even if it would be highly appreciated if you could. And the same, and because as maybe Adam Rixer and Katarzyna could confirm, whole event is also aiming to gather us all together, and it will be associated a social event attached to the conference. And the same is even to Judith. Maybe we could find an opportunity for Judith to come. Obviously, she could be hosted by organizers. I'm not sure only about the cost of the fly for her, but she's also invited, and I think that it would be a very good occasion to meet us all together, because I suppose that the whole research in this form or some other form will be possible in future. So it would be a good first step to meet us, not like this just online virtual existence. So the other, I suppose, it is a group who will be present for sure. So we'll see you soon. I will contact you about the workshop and the term of workshop. So we will discuss when we would like to meet. And then, as I told you, because I just established this with organizers, the last seminar will be the first week of December. So after the conference, because I suppose this is impossible to organize the seminar before the 21st November. Is very soon and very short notice. So with any risk, we can do the last seminar the first week of December. So have a nice evening. Thank you, our guests, to join us and being up to the end. Whole event is recorded, so I suppose that we could have other visitors in few days or few weeks, so you can share the record, and then we are of course willing to answer the whole questions. Our emails address are given on the website. If not, it is easy to find us by our names, as we are scholars. So thank you for today, and please wait for my message about the workshop. Thank you.
Thank you very much.